I'm Janice Switlo. This is part 23 of my book, Cede 2.0, regarding the First Nation Land Management Act regime. If Indigenous nations no longer wish Her Majesty to administer the reserves, there would need to be a formal amendment to treaties or protocol. There is no such process set out in the treaties, so it would again require diplomacy and agreement between heads of state. This is always problematic on the Indigenous nations side, given very decentralized, often fluid nations' governance structures. They would need to again, as was done when the treaties were negotiated and entered into, point out to the Crown who their diplomats and authorized people are, and I'm not talking about leaders of regional and national lobby groups like the AFN, Assembly of First Nations. It is critical to understand, though, that there are other ways that treaties can be amended, by change in customary international law and by party behavior. The Crown party to the treaties cannot unilaterally impose its desired interpretation of her legal obligations under the treaties, but where state behavior evidences that new, e.g. Section 35 interpretation of treaty, and the Indigenous nations do not explicitly disavow that initially unilateral interpretation, then consent to the amendment is implied. Consent by the parties to that new interpretation has the legal effect of adding to or amending the treaties. This is called authentic interpretation. It originates from the time of Emperor Justinian, who made himself omnipotent, giving himself the final competence to interpret a law. Quote, Justinian's rise to imperial power began in 527 with his appointment as co-emperor to Justin I, his uncle, who died later that same year. His sole rule was characterized by profound efforts to strengthen the empire and return the state to its former ancient glory. To this end, Justinian drew upon administrators and counselors from outside the aristocratic class. His own modest origins, along with his selection of these court members, contributed to lasting tensions with the Byzantine's nobility. This situation was exacerbated by Justinian's authoritarian approach to governance, and his pronouncement that the emperor's will was law further undermined the authority of the Senate as well as its factions. Popular outrage at Justinian's policies crystallized in the Nika riot, Nika meaning conquer, in the Hippodrome of Constantinople during the period January 11 to 19, 532. This period of civil unrest resulted in the burning of several important religious and imperial buildings, including Constantinople's cathedral, the 4th century church of Hagia Sophia, the Church of the Holy Wisdom of God, the Church of Peace, the chalk or bronze gate to the imperial palace, and the baths of Zeuxippus. The resulting damage to Constantinople's Palatine and religious center at the southeastern end of the city would allow Justinian an opportunity for extensive rebuilding in the years to follow. In the religious sphere, Justinian took a leading role in shaping church policy. As an adamant defender of Christian orthodoxy, he fought to extinguish the last vestiges of Greco-Roman paganism, to root out Manichaeans and Samaritans, and to oppose competing Christian sects, including the Arians and the Monophysites. Justinian also came into direct conflict with the papacy in 543, further straining relations between the western and eastern territories of his empire. In foreign policy, Justinian sought to recover regions lost to foreign invaders, particularly Germanic tribes in Italy and North Africa. He thus launched one of the most aggressive military programs in medieval history. As a result of his reconquest of the empire's former western territories, he restored Ravenna's status as a capital in Italy. Mosaic portraits of Justinian and his wife, the Empress Theodora, appear there at the Church of San Vitale. By his death in 565, the empire bordered nearly the entire Mediterranean Sea, a size unrivaled in Byzantine history from that point onward. Conquest and territorial reorganization were paralleled by reforms in state taxation and legislation, the latter codified in the Corpus Juris Civilis, corpus of civil law, a text that today forms part of the foundation of the Western legal system. Many Indigenous nations will recall the time when their chiefs, their nobility, were murdered and or removed from governance and replaced by councillors under the Indian Act. A twofold strategy of conversion of land and of the termination of the heathens being an application of a strategy that had proven effective for many hundreds of years of conquest. But history also warns of the explosive reaction such strategies have provoked. Here, Section 35 of the Constitution Act 1982 has been interpreted by Supreme Court of Canada justices to such effect that the new interpretation of the treaties is just some sui generis domestic contract subject to a limitation provision that is not even written in the Constitution Act 1982, not found outside the Charter of Rights and Freedoms. Section 35 falls outside of the Charter and begins Part 2 of the Constitution Act 1982. Section 1, serving to limit the rights, quote, protected, end of quote, in the Charter, reads as follows. 1. The Canadian Charter of Rights and Freedoms guarantees the rights and freedoms set out in it, subject only to such reasonable limits prescribed by law as can be demonstrably justified in a free and democratic society, end of quote. The two main Supreme Court of Canada precedent cases on the interpretation of Section 1 of the Charter are R v. Big M Drug Mart Ltd. 1985, 1 SCR 295, and R v. Oaks 1986, 1 SCR 103. Big M Drug Mart held that Section 1 limitations on rights are only constitutional when motivated by an objective of sufficient importance and the limit is as small as possible. In Oaks, the Supreme Court elaborated by setting out that the factual analysis must support a pressing and substantive objective. The means is to be proportionate. The means is rationally connected to the objective. There is minimal impairment of rights, and there is proportionality between the infringement and objective. A Section 1 equivalent could not be written in Section 35 of the Constitution Act 1982 as the British Parliament had to approve the constitutional amendments to, quote, repatriate, end of quote, Canada's Constitution, and Her Majesty was bound by the treaties, being the higher and foundational constitutional documents. So there could be no limits placed on them in the lower constitutional document then being proposed. It could not be written into the proposed constitutional document because the Crown could not limit her treaty obligations, being permanent. So to get it passed in England, recourse was to leave it out of Section 35 of the Constitution Act 1982, but then insert it through the courts. This was how to wrap this up into a singular Crown sovereignty, ending all permanent Crown legal obligations, turning them into ethnic minority concepts of fair dealings, but always subject to annual parliamentary appropriations. But it required cooperation of lawyers and their client chiefs and councils, trusting in their lawyers, of course. Academics suggest that with Section 35 falling outside the Charter and being in Part 2 of the Constitution Act 1982, that this exempts Section 35 from the notwithstanding clause that applies to the Charter, so as to prevent governments from overriding Aboriginal rights. The notwithstanding clause reads as follows. Section 33. 1. Parliament or the legislature of a province may expressly declare in an act of Parliament or of the legislature, as the case may be, that the act or a provision thereof shall operate notwithstanding a provision included in Section 2 or Sections 7 to 15. Sub 2, an act or a provision of an act in respect of which a declaration made under this section is in effect shall have such operation as it would have but for the provision of this charter referenced to in the declaration. 3. A declaration made under subsection 1 shall cease to have effect 5 years after it comes into force or on such earlier date as may be specified in the declaration. Sub 4. Parliament or the legislature of a province may reenact a declaration made under subsection sub 1. 5. Subsection 3 applies in respect of a reenactment made under subsection 4. Stay tuned for a notwithstanding clause equivalent being read in by the courts. It has already begun. The Supreme Court of Canada has already done it once, exceeding the lawful jurisdiction by reading into the Constitution Act 1982 that which is not written therein, thus not being a lawful exercise of interpretation of a constitutional provision. So it is an even easier step to conclude the Justinian strategy to judicially create a parallel notwithstanding clause, just as the Section 1 parallel clause was created. The rule of law is indeed the rule of plunder in Canada when it comes to Indigenous nations. Might this Justinian strategy hope to be concluded by Justin Trudeau, leader of the Liberal Party of Canada, seeking to become Prime Minister in Canada's 2015 election, finishing that which his father, Pierre Elliott Trudeau, began? Of course, Justin Trudeau did become Canada's Prime Minister in 2015 and continues today in that role.